All right, Sarah, I think we should get started. I guess I'll introduce you. I'm going to take it upon myself to introduce the great Sarah Forrester, Assistant Attorney General at the Maine Department of Education, and the most amazing attorney and knowledgeable about special education and IDEA and all things. Um, Thank you for joining us today. We're going to be doing, this is a eight-part series.
Seven.
Sorry, seven-part series. And then in between the 2 weeks, Roberta and I will be meeting with you all to reinforce and do follow up on a more deep dive, digging into any questions or specific scenarios or cases that you would want to get some more information on. So I hope you all enjoy this. We are recording it if you were not able to attend in person. And so thank you for being here. Sarah, take it away.
All right, so I'm so excited that we're finally starting again. It has been 12 years since we all got together to talk special education law. Now, of course, that's a total lie because you all think about special education law every day, and I think about special education law every day. We just don't do it together. And so the excitement is, of course, that, at least for me, now we're able to do it together again. Like Erin said, I'm Sarah Forster. I'm an Assistant Attorney General, and my clients are all of the state education operations, which means you. You have been my client now for a really long time. Let's just leave it at that. And throughout those years, I have never not been impressed by what it is that you do. So whenever you think that CDS has no fans, in fact, they have one, at least as a minimum, and that would be me. What else about me? Well, the last time we were together, I had a wonderful little boy that made me an aunt. That wonderful little boy is now a high school freshman. He's still wonderful, but he's a high school freshman. When we last did one of these trainings, let's see, oh, Tigger the cat was alive. She's since left me after 22 years of felonious givings and takings. She is, though, remembered by Jan Breton and many in the education community because of that very bad day when I snapped, my cat could open a private school and issue high school diplomas in Maine, and she wouldn't be doing anything illegal. You know, some animals live longer than their actual lives. So because there's so many of you on this call, and because we have to do this in 2020 fashion, okay, remotely, I wish all of you could introduce yourselves to me, but the truth is some of you I've known for many, many years, and some of you I've just met, and some of you I've never actually met, but I do know a few things about you generally. I know, for example, that you are very much the heart and the engine behind what I refer to casually as Fape Nation. In other words, none of this would be working without you all. As I often tell people, as a lawyer, I have never, not once, educated a child. I help, I think. I support, I think. But you all are the folks that are actually doing it. Also joining us are a number of people from the Department of Education. Obviously, you know that Erin and Roberta are on the line, but you might also want to know that there are other people from around the 5th floor of the Cross State Office Building, although most of them aren't actually there. And that's because they've expressed interest in special education law and in what you do. And many of them are people who in some way, shape, or form have some impact on what you do or could have an impact on what you do. So I'm glad that they're here too, learning with you and with us, because I always think that the only way we're going to do these things is if we do them together. And so it's literally a case of the more the merrier as far as I'm concerned. All right, well, I suppose there's one last introduction I have to make because he'll make an appearance at the most inappropriate time. Oliver the cat lives with me now, and he's sort of become a permanent presence in this whole work from home, Sarah, work at your dining room table, Sarah. From time to time, he'll hop up and walk across the screen just because, well, he is. And he would also like you to know that he considers himself to be the first cat of Fape Nation. He also is trying to build an internet presence, despite the fact that he's been strictly prohibited from me by having any accounts, no Instagram, no Facebook. And he likes the hashtag FapeCat. At any rate, don't be alarmed if an orange animal walks across the screen. It's all perfectly normal. So I want to talk a minute about this Fape Nation thing, because the reality is, for people who know me, I make up words all the time, and oftentimes those words sound like actual real words, and sometimes they're just true gibberish. But the truth is, Fape Nation is real. I'm not sure everyone calls it the same thing, but to me, Fape Nation means that we live in a country and in a state where we all work hard to make sure that every child, every kid has access and opportunity in the field of education. And so being a part of Fape Nation, I would argue, is a badge of honor. In other words, who wants to be an anti-Fape, right? So you want to exclude people? You want people not to be able to participate with their friends and little colleagues? Of course not. But you all are the real motor behind Fape Nation. And so that's why you'll often see me use it, either in emails with you or in conversation here. Fape Nation is real, and we're all a part of it. And frankly, that's a good thing. Oh, I suppose there's one more thing that I should say before we get started. So many of you know that the legislature has once again taken an interest in CDS. This is not at all an unusual event. I was cleaning through some files the other day, yes, in a rare time when I was actually in my office, and I have about, 5,000, 10,000 pages of various reports about CDS. I want to make two things really clear. First of all, this class and this happening right now has exactly zero to do with anything that they're talking about. This is because I recognized, and Erin and Roberta recognized, that it's been too long since we all got together to talk the basics. It has nothing to do with what anyone else might think. And then the second thing, and I realize this is recording, but life is short. Don't believe everything you hear. In fact, don't believe any of it. We're going to figure it out. We always figure it out. Nothing's going to change, except that we're going to get better together, because together we can do these things in ways that we can never do apart. So that's all I will say about any ongoing legislative interest in the operation. All right, so here I go. We're going to go with my very limited skills. The question is, how do I get to share my screen again? I've lost all the little buttons down here, one of which was share my screen. Come back.
Sarah, try mousing over at the bottom of your screen or the bottom of your monitor.
Try mousing over your screen. It's back. It's back. You can tell that when I said in my email that my skills are nascent, I am not a liar. Okay. Here we go. So we're going to jump in. This is session 1 of Special Education Law for CDS. We're going to talk a little bit about an introduction to the course, and then we're going to jump right into the legal framework within which you operate, and we're going to focus on key terms and concepts that you're going to hear about and talk about ad nauseum through this course, through all of the great sessions that Roberta and Erin are going to do, and frankly, in your everyday work, like every day. The plan here is to provide an overview of the laws and regulations. Now, mostly this is going to be IDEA's Part B, Section 619, and MUSER, the Maine Unified Special Education Regulations that are applicable to students with disabilities from age 3 to school age 5. And as Erin suggested, this is not just going to be a series of me talking and, oh goodness, I don't know what else. Erin and Roberta and others with expertise, okay, it might include me, but only in a minimal role, are going to do some follow-up work with you so that you will have the opportunity to drill down into how you're actually supposed to do these things. Because as I said, just like I've never educated a child myself, you could listen to all this and say, well, that's quite fabulous and you're almost amusing when you deliver it. But what am I supposed to do on a day in, day out basis? Don't worry, that's included in this too. So we're going to do this in 7 weeks, spread out over a little more than 7 weeks, because there are a few winter holidays that we want to acknowledge. Today, like I said, we'll talk about the introduction, legal frameworks, and key terms and concepts. Next week, we will start with child find and talk about referrals, the role of the IEP team, and a very hot topic of late, records, both paper, electronic, and everything else. In week 3, we'll tackle evaluations and eligibility. And then in week 4, the mother load, Fape. We're going to break Fape in half because it's such an important topic that it deserves 2 weeks. The first week, we'll talk about the procedural requirements for Fape. And then the second week, we'll tackle the substantive standard. In other words, what exactly is a Fape and how do you know whether or not you're offering one? In week 6, we'll talk about an all-time favorite topic, least restrictive environment, the LRE. We'll talk about placement and changes of placement. And then week 7, we'll talk about the document that only lawyers can love, the procedural safeguards, including dispute resolution. So, a few introductory questions that I've heard about this course. No, there is no text. That doesn't mean that Erin and Roberta and I haven't been talking about some useful resources that we might have available for you, but there is no official textbook for this course. If you can believe it, even though we've all gone to like 10 webinars about how to have a successful PowerPoint, I still insist that, at least for this class, these PowerPoint slides are going to be dense and wordy because they are, in fact, the basis of your written materials. Other things you'll want to have available to you as we work through the material. First of all, a copy of Muser. I'm sure that all of you know that it's available electronically. You can pull it down from the Secretary of State's website. The other thing we're going to be talking about is CDS's policy manual. And between this week and next week, we will figure out how to get a draft version of the CDS policy manual, which I know is in the process of being worked on. Heck, every policy manual I've ever known is in the process of being worked on, trust me. But we're going to be looking at some of the language and policies in that, so we'll make sure that you have a copy of that available as well. Oh, by the way, there's no final exam at the end of this either. And I will figure out how to properly communicate with the Department of Education's certification unit to see what, if anything, can be done to have you, I don't even know what the right word is, Fape certified. So.
We will provide contact hours.
Contact hours. Excellent. I love the idea that contact hours can be, well, without any actual physical contact. Fabulous. Okay, so you need to follow the law. Isn't that a really great thing for your lawyer to tell you? You probably thought, thank goodness we don't pay this woman by the hour. She's sort of a captured thing. Because obviously, we all have to follow the law. But here's the thing. A lot of people, including some of those who make it, don't actually know what the law even means. So let's step back a minute and talk a little bit about what is the law. Is someone unmuted? What is the law? when it comes to CDS. So, okay, all of us survived well, most of us survived high school unscathed. What did we learn? Well, we started with the Constitution. The Constitution, some very wise social studies teacher or American government teacher told us, is the source of all law. What does that actually mean? Well, it essentially means that every piece of whatever else I'm going to tell you the law is, has to have a basis in the Constitution. If it doesn't, it's not a valid law. There is no mention of education in the US Constitution, not one word, not at all. On the other hand, education is specifically mentioned in the Maine Constitution. And here's your first opportunity for a cocktail party stumper. According to the Maine Constitution, how much aid, state aid, is required to be given to the towns and cities? Answer, none. The Maine Constitution places the responsibility for public education, including its funding, 100% on what they refer to as the several towns. Now, that's not the truth, of course. There's always been state money for education, but none of that is required by the Maine Constitution. So how is it that the federal government got involved in this whole Fape thing at all? You just told us that it's not in the US Constitution. Well, education may not be in the Constitution, but the Constitution contains some other parts. Most importantly for our purposes, what's referred to as the spending clause or the general welfare clause. That allows Congress to give money to states to support the general welfare. And not surprisingly, that is the source of where IDEA's dollars come from. Another important part of the Constitution, the 14th Amendment, the right to equal protection. As we'll see in a few slides, that right to equal protection provided the legal basis for some attorneys 40 plus years ago to start us rolling on the notion that children with disabilities have an equal right to participate in public education. Due process. Now, this is like the big capital D, capital P due process, not like, oh no, we're going to have a due process hearing, but they actually aren't disconnected, because the concept of when you receive a government benefit, it shouldn't be taken away from you without some amount of due process is not completely detached from IDEA's due process system. And we'll be talking about that too. So after the Constitution, another part of the law are statutes. In other words, laws. Statutes are simply a law passed by a legislative body. Statutes are meant to be broad statements of policy. In other words, they give a big, broad outline of what's expected. IDEA is a statute. Title 20A, all of the Maine education statutes, particularly for our purposes, chapters 301 and 303 that deal with special education in Maine. All of those things are statutes, and all of those things exist because they're contemplated by the Constitution. Another type of the law is a regulation or a rule. These don't come from the legislature. They start at executive agencies. In other words, the Department of Education, as an executive agency, has rulemaking authority. But there's a catch. In Maine, we like to do things differently. And so we have a subset of rules that are called major substantive rules. These are rules that after they are promulgated by the executive agency and provisionally adopted, they go to the legislature, and then the legislature has approval authority. A rule is much more specific than a statute. It implements or interprets or makes specific the law administered by the agency. In federal terms, IDEA's rules are at what we call Part 300. And in Maine, that's where we get MUSER. From a practical perspective, 99.9% of the time, you're going to be looking at MUSER as the law. That's not because we don't have statute, and it's not because we don't have federal statute and regulation, but because of the way MUSER's written and its incorporation of federal language, MUSER provides basically a one-stop legal shop for you. So before we leave this, we've got to talk about something else, otherwise known as everything that's not the Constitution, a statute, or a rule. Bold letters, not the law. So we often get Dear Colleague letters from the US Department of Education. Okay, a little hint, they're not writing to us because they think we're either dear or they really think that we're their colleagues. They're great. They give what the US Department of Education believes the law to be, but they are not themselves the law. Other things you might see. Sometimes OSEP puts out frequently asked questions or Q&As, and just to be fair, so does the Department of Education. You know what those things are? Not the law. These are all agency interpretations of the law that are meant to help and guide you. But the truth is, at the end of the day, they are not enforceable. Not the law. Okay, so maybe about 50% of you saw this next slide and thought, oh dear Lord, where is she going? And why is she starting here? So let me give you 3 really good reasons why we need to start at the very beginning. First of all, as we work our way through the next 20 minutes or so, I hope you realize that all of this contributes to the purpose behind what we're doing. We didn't get to Fape easily. This was not something that people instantly thought was a magical cure or the perfect way to run an education system. In fact, it was quite the opposite. Second, from a very practical sense, by the end of this session, you're going to have seen and heard all of the major terms in IDEA. And they came from somewhere, and you're going to know where they came from. And when you know where they came from, it makes you more able to understand what they mean and how to apply them. Okay, here's the third thing. Important lesson, whether you're a lawyer or an educator or anyone else that's on this session. Never forget the basics. About 6 months ago, I was in court with an attorney that I think of as one of the real leaders in our profession. And wouldn't you know, he'd forgotten one of the rules and hadn't complied with one of the rules. And that ended up costing him and his client. And it occurred to me, my goodness, he's probably done this literally hundreds of times. How could that happen? And it reminded me of this essential truth. We always need to return to the basics. We always need to return to the basics. Because just when you think you don't need it anymore, something like that happens. You forget something that's so basic and so fundamental, you would think that it would be impossible to forget. So let's talk about how we got to Fape. We're going to start where I would argue all of modern education law starts, which is Brown versus Board of Education and the desegregation of America's schools. We're then going to move to the 1970s and a huge storm of things happening at the same time. We're going to have the Park case and the Mills case. We're going to see Section 504 of the Rehabilitation Act enacted. And then quickly thereafter, the Education for All Handicapped Children Act, which was renamed the Individuals with Disabilities Education Act, or IDEA. There is one thing missing from this slide that I do want to point out, which is that in between the 50s and the 70s came another important piece of legislation, the Elementary and Secondary Education Act of 1965. This was the education plank of then President Johnson's War on Poverty. And President Johnson, he told us, was a living exhibit of how education had lifted him out of poverty. And so it was critical in his mind that additional resources flow to the most vulnerable students. And by vulnerable, he meant students who were experiencing poverty. That program has brought us both, or more than, the basic title programs. It also involves migrant education. It involves bilingual education and English language learners. It involves the Head Start program. And with the Equal Educational Opportunities Act of 1974, it codified anti-discrimination language in all federal education programs. So while we now refer to it as ESSA, and for a long time referred to it as No Child Left Behind, that's another important part of our legal history and of our story here. But let's think about public education and how we started. We refer to public education as a birthright in this country. And I realize that the term birthright has been taken and corrupted in ways that are perhaps not as flattering as it was intended to be. The right to a public education appears in every state constitution. But as a reality check, the reality is that at the founding, boys of means were the only people who were educated. Eventually, boys and girls were educated. All boys and girls, regardless of race, after Brown versus Board of Education. In other words, I read a statistic right around the election that said, when the Constitution was adopted, only 8% of American citizens had the right to vote. Suffice it to say that it's probably true that as state constitutions came into being, including the right to a public education, that right started out small, but it's grown and grown and grown. Along with this birthright is a parallel track, compulsory education laws. In every state, all children within a certain age range are required to be educated. In fact, there are sanctions for non-compliant parents. I mean, you've got to blame somebody, right? Now be clear, parents have the right to choose private or an alternate education that was established by Pierce versus Society of Sisters. But in total, there are compulsory education laws that cover all kids in Maine within a given age range. Now, as these compulsory education laws went into effect, along with them came an unfortunate interpretation, which was, well, compulsory education laws couldn't possibly apply to students who are uneducable. Uneducable? Yep. Actual language got built into compulsory education laws, excluding students with disabilities, essentially deeming them uneducable. Then comes Brown versus Board of Education in 1954. And we'll jump right to the money language. It is a right that must be made available to all on equal terms. So, an education where the state has undertaken to provide it is a right that must be made available to all on equal terms. Lawyers were paying a lot of attention to that language. What did we learn? Well, under the equal protection of the law, a class of individuals, not just a particular individual, can be entitled to equal protection. Black students had the same right to attend public schools as white students. So it didn't take long for lawyers to start thinking, what if we argued that students with disabilities had the same right to attend public schools as non-disabled students. So we get to the 70s and Park and Mills. And Park is an acronym that stands for Pennsylvania Association of Retarded Citizens. One thing we'll see is that language has meaning, but language evolves. That was the actual organization's name, and so that was the language that we used. These were two cases that challenged state statutes and policies that excluded students with disabilities from public education. Both of these cases were class actions. In other words, they were bringing these claims on behalf of all of the children who were being excluded. Park was resolved by what we call a consent agreement. In other words, a settlement. And because it was a settlement that involved minors, it had to be approved by the court. The language from Park and Mills appears in the IDEA to this day. Here's what the Park Court found. Retarded children in Pennsylvania were entitled to placement in a free public program of education and training appropriate to their capacity within the context of a presumption that placement in a regular public school class is preferable to a placement in a special public school class, and placement in a special public school class is preferable to placement in any other type of education or training. Sound familiar? In 1972, the Mills case examined the rights of all children with disabilities, and the Mills court specifically found that the failure to provide a public education cannot be excused by the claim that there are insufficient funds. The Mills court adopted a plan that included a free appropriate education, an individualized educational plan, and due process procedures, all language that we all know because we use it today. Just as this was all happening, Congress passed Section 504 of the Rehabilitation Act, which insists that no otherwise qualified handicapped individual in the United States should be excluded by reason of his or her handicap from participation in or be denied the benefit of or subjected to discrimination under any program or activity receiving federal financial assistance. So take a step back. What is a program that uses and receives huge amounts of federal financial assistance? Well, how about public schools? There was a huge impact on public schools with Section 504. And unlike other statutes, Section 504 doesn't come with dedicated funds to pay for compliance. So Congress identified that financial assistance was needed in order to help schools come into compliance with Section 504 and to continue the work done in Park and Mills. 1975, here we have the Education for All Handicapped Children Act. What's there? A Fape, a free appropriate public education, an IEP, an individualized education program, special education services, related services, the least restrictive environment, and due process procedures. Exactly what we have today. Now, the EAHCA is a statute that gets reauthorized every few years. And reauthorization simply means that Congress takes a look at an existing statute, makes some modifications, and readopts it. In 1986, for the first time, children aged 3 to 5 years old were included in Part B, what we now think of as Section 619. Also in 1986, Part H, which we now call Part C, was added to serve infants and toddlers with disabilities from birth to age 3. In 1990, the name was changed to IDEA as we know it today. And in 1997, not only did Part C become the former Part H, but the statute specifically recognized that the least restrictive environment principle applied to 3 to 5-year-olds. The current reauthorization of IDEA is from 2004. In other words, reauthorization is way overdue sitting here in 2020. If you look at the other gaps, 1986, 1990, 1997, 2004, we're just kind of behind. But the reality is, with a pandemic, with a federal budget and state budgets kind of in free fall because of the pandemic, let's just say there are a lot of things on the president-elect's plate and on the incoming Congress's plate that don't include reauthorization of IDEA just now. So in 2004, that would be the current reauthorization. How funny and old is this? The point was to align the IDEA with No Child Left Behind. Okay, no longer No Child Left Behind. Highly qualified special education teachers came into being. IEP team participation changed. You could amend an IEP without a team meeting. The discipline rules changed, well, again, and they clarified the dispute resolution processes, including involving, in the case of a due process hearing, a required resolution session. So where are we today? IDEA includes the key terms and concepts deriving nearly verbatim from Park and Mills. The statute itself has never been particularly well organized substantively, but the 2007 regulations that were meant to pair up with the 2004 reauthorization are actually grouped substantively for the first time, which I have to tell you, for lawyers, is the best. And also, each of the statutory principles has been informed over the years by case law. So we know what the courts think about almost every piece of IDEA. Okay, so key components of IDEA, all of which come from this very important historical beginning. First, we'll talk about the zero reject principle. Then we'll move on to the protections in evaluation, a free appropriate public education in the least restrictive environment, the important parental participation in all decision-making, and yes, the procedural safeguards. What is the zero reject principle? Well, if you look at the text of IDEA, each state education agency and each local education agency are responsible for identifying and serving all children with disabilities aged 3 through 21, and ages 3 to 5 are only if the state accepts Section 619 funds. Footnote, every state accepts Section 619 funds. So, in Maine, the LEAs are called school administrative units, and they are all of the K-12 school units and CDS. But CDS is not actually the same as a public school unit. You're something special called an intermediate educational unit, and I could tell you way too much about how you got that way. And in fact, the term intermediate educational unit hasn't even been in IDEA for like a zillion years, although once an intermediate educational unit, always. In other words, you're grandparented in forever. You were created specifically to avoid giving the burden of 3 to 5-year-olds to the public schools. And so you have exclusive authority to deal with special education for the 3 to 5-year-olds before they become, quote, school age 5. So about that reject thing. Timothy W. versus Rochester, New Hampshire School District is a case from our very own First Circuit. Maine, when it comes to the federal courts, is part of the First Circuit. There are actually 13 circuits in the country. A bunch of them are geographical, numbered 1 through 11. And then there's the DC Circuit, which is also geographical, but didn't get a number. And then there's the Federal Circuit, and well, they don't have anything to do with this. But the key thing is that Maine is in the First Circuit. And so when it comes to precedent, when it comes to the case law that we're required to follow, the First Circuit is it. Timothy W. is an important case. It's so important that even the other circuits follow it. Timothy W. was a child whose brain had never fully developed. He literally had not a complete brain on top of his spinal cord. It just didn't exist. And his school district took the position that he was so disabled that IDEA couldn't possibly apply to him because he wouldn't be able to benefit. If the purpose of IDEA, they said, was to make sure that children are able to access and benefit from their education, Timothy couldn't benefit. His parents sued, and the First Circuit stated that all children with disabilities, without exception, are entitled to services under the IDEA. There is no such thing as being too disabled for the IDEA, and there is no requirement that a child be able to benefit as a sort of gate to IDEA and its services. Simply put, a child is eligible for services under Part B of the IDEA if the child has a disability that is covered under the IDEA or is experiencing developmentally delayed, if the state has chosen to allow that for children aged 3 to 9 or some subset thereof. And as you all probably know, Maine allows CDS to use developmental delay. So that's part 1. A student has to have a disability or be experiencing developmental delay. And 2, by reason thereof, the child needs special education and related services. Now, the regulations add what many think of as a third requirement, which is that the child's disability has to adversely affect their educational performance. And we'll talk about in a few weeks how adverse effect, at least for some time, became quite a hot topic in Maine. But the key is, has a disability or experiencing developmental delay, adversely affects educational performance, and as a result, the child needs special education and related services. Protection and evaluations. IDEA is very specific as to what the rules are for evaluations. They must be completed in a timely manner and at no cost to the family. The evaluation materials have to be non-discriminatory. They have to be in the child's native language. They need to be technically sound, administered by qualified personnel, and they need to determine what the students can do, not just what they cannot. Students have the right to be assessed in all areas of suspected disability, and you're obligated to use a variety of assessment tools and strategies to collect information. Documentation is critical. And finally, the eligibility decisions must be made by a team of people, including the parent. Here it is, a Fape. What is a Fape? Oh, it just happens to be special education and related services that are provided at public expense and under public supervision that meet the standards of the state education agency and that include an appropriate preschool, elementary, or secondary education and are delivered in accordance with the child's IEP. How do we know about this? Because in 1982, the Supreme Court, in the Rowley decision, tried to explain what a Fape is. And to be clear, they actually didn't tell us much, considering that we were going to have to live with this going forward. There are two questions, the Supreme Court said. One, has the state or the LEA complied with the procedures in the Act? And number two, is the IEP reasonably calculated to enable the child to receive educational benefit? We hold that the state or the LEA satisfies the Fape requirement by providing personalized instruction with sufficient support services to permit the child to benefit educationally from that instruction. Okay, so all in one slide, you now can probably figure out how it was that I got the idea to divide Fape into the procedural part and the substantive part, right? Really creative, huh? And all of these concepts, complying with the procedures, reasonable calculation, educational benefit, we're going to break apart all of those as we go through the course together. But if you had to ask, what is the Fape test? There it is. Okay, until 2017. After all these years of all these due process hearings and all these courts trying to figure out what Fape is, the Supreme Court got into the Act again. And they got into the Act because they had a case that asked the question, how much educational benefit? As it happened, the lower court in that particular case was in a circuit that had the de minimis rule. And basically the de minimis rule was that an IEP was sufficient if the student was making some de minimis educational benefit. In other words, in this one area of the country that was governed by the law of that circuit, you could have a perfectly good IEP if you were getting not much. Now, Maine has never had that as the standard. The First Circuit has always been more aggressive. They've always defined it as a meaningful educational benefit. But here was the Supreme Court with this other case. And the court looked at it a little differently than the Rowley court had years ago, because after all these years, one thing that became clear is that there are in many ways sort of two groups in a very big sense of students that are receiving services under the IDEA. The first group is a group that's able to stay with its grade. Essentially, these are students that with appropriate specialized instruction and supports and related services are able to keep up with their age peers. The second group is a more difficult group to plan for because they're quite behind their age peers. In other words, these are students for whom participation in a regular education setting or using the regular education curriculum with minimal modification is simply not possible. So how do you decide, the court was asked, whether or not an IEP for this second group of students is appropriate? With the first group of students, obviously, you look at whether or not they're able to move from grade to grade along with their age peers. But what about the second group? And here's what the court said. It must be appropriately ambitious in light of the student's circumstances, just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. The goals may differ, but every child should have the chance to meet challenging objectives. So definitely the First Circuit had it right. It is more than a de minimis standard. There has to be some meaningful educational benefit. The least restrictive environment. To the maximum extent appropriate, children with disabilities are to be educated with children who are not disabled. And removal from a regular education environment can occur only when education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. You'll hear me say throughout the course that the way to think about the least restrictive environment is to think of a set of twins. One is eligible under the IDEA as a student with a disability, and one is not. You start the discussion about LRE by asking, where is the neurotypical or the typically developing twin going to receive his or her public education? That's where you start for their disabled twin. Twin with a disability? Something like that. You start in the school the child would otherwise attend, and you work your way through a continuum of placements that includes everything from regular educational classes, reverse mainstream or weighted classes, special schools, and even to the point where education is provided in hospitals, institutions, or in the child's home. Parental participation. Parents are entitled to notice of IEP team meetings and the opportunity to participate in IEP team meetings. And if I could put a little carrot in there, I would say the opportunity to participate meaningfully in IEP team meetings. Parents give consent before initial evaluation, initial provision of services, any reevaluations, and parents have the right to withdraw consent, which, by the way, is not retroactive. Parents are entitled to prior written notice. Basically, what is the school proposing or refusing to do, and why? Based on what? What was considered? What was rejected? And finally, the procedural safeguards. They're a written document that contain the basic rights of parents, the right to participate in decisions about the education of the child and have appropriate individuals present for discussions, the right to determine whether or not their child will receive special education and related services, the right to examine their child's education records and to protect the confidentiality of information about their child and their family, and the right to engage in dispute resolution through mediation, through a state complaint investigation, through a due process hearing. All of those rights are actually provided to parents annually and anytime when there is a dispute. Okay, I'm going to stop at the share. So here's where we are. That's a little bit about how we got there, and it's a little bit about where we're going. Because in the next few weeks, every one of those terms that I just whipped through are going to become an important part of our discussion. We're going to be in a situation where all of you are going to bring what you know and what you've experienced to the table, and we're going to work through what the law says about all of that work. So I realized this was a difficult way to start in the sense that it was almost impossible to do in a way so that any of you could ask any questions. But I'm pretty brave on this front. I mean, you know, stumping the lawyer is always something that, you know, it's kind of like one of those Thanksgiving after turkey family games. Does anyone have any questions that they want to raise at this point? And I believe you can do that through the chat box. See, I'm actually learning this stuff. So before we go, does anyone have anything they want to say in the chat box? I probably should have said, put your questions in the chat box while this is all going along, right? Because then Erin would tell me you have questions at the end that you can respond to. These are the reasons why they rarely let me do these things. I mean, 12 years is kind of a long time to wait, but when they learned that it was going to have something to do with me using Zoom, everyone got really frightened really fast.
Not so, Sarah. We're not frightened. We know Oliver's there in the background helping you, supporting you in your role.
Yeah. I mean, if it hadn't been for the windstorm last night, he wouldn't have had to guard the house. If he didn't have to guard the house all night, he wouldn't be so exhausted that he couldn't come to the first session of special ed for CDS. In fact, I think I can see him in the distance, flopped out on the couch. He's probably snoring.
I did want to tell people, because some people don't know what MUSER stands for. Maybe I'm not going to assume you don't, but MUSER is Maine Unified Special Education Regulations, and it's basically tied to IDEA. And we have put the link in the chat box for you for the multiple hundreds of pages of MUSER. Right now, Part C and Part B are together in MUSER, and we're working on a project to disentangle those two, which, rewriting something like MUSER takes a couple years to do. So, but that is something that we're going to be looking at doing. And so that document is in the chat box for you. If there's no other general questions, we'll wait for a couple minutes because I think we have, this is for an hour, I forget, yeah, a little bit over an hour. So if there's no general questions, I know this is a lot. It's the foundational work that's going to be kind of giving you guys a historic reference for, first of all, how long we've come. We've come a long way. And certainly trying to make sure you have an understanding of the history so that you can understand why we pay a lot of attention to least restrictive environment. And also right now, I know a lot of you are paying attention to the meetings that you're having and having parents participate in those meetings fully. So that's something that's been kind of on our agenda.
So I would just say, timing wise, I've blocked all of these as an hour and a half because I'm sort of creating it as it goes along. Since I haven't run this particular version before, I'm not sure where between the hour and the hour and a half this is going to fall. So, we got to be fluid, right? Flexible. It's 2020.
Yeah, we're all adaptive here. We all do a good job. Just so you know, so on the weeks that Sarah's not presenting, so next week, the 23rd, by the way, it's Thanksgiving next week. I don't know how many of you are horrified by that because it's already like almost the end of the year, and happy because it's almost the end of the year. So we'll be meeting with you next Monday during this time period. And you don't necessarily have to be thinking about questions as they relate to these items, but we would like to, certainly there are certain things that kind of drive what we're doing right now, especially thinking about Part B as one Part B 3 to 20 as one unit. So you can come to that. It's a drop-in session. You can ask general questions or you can relate that back to the work we do, because these cases they do have, the cases that are certainly in the First Circuit all have, and Andrew F. certainly had a big impact on how we approach special education. I think every case that goes through our office is citing Andrew F. these days. And I just got feedback that it needs to be on our website, Sarah. So tell me how we do that. The Department of Education in DC wants Andrew F. to be on our website. So that's interesting. We'll talk about that later.
How do I say this politely? Yeah. The Department of Education in DC is going to be in flux for a few weeks. I think that, we might want to press pause on what we do and when we do it. So now I have a question. You all are doing next Monday? Because I had next Monday scheduled for me. So maybe I misunderstood.
No, you aren't misunderstanding. It's me that's misunderstanding. If you thought that we were doing a training next week on Fape, we're doing a training next week on Fape. That was how I was thinking of it, but so we have not scheduled that. We will do that by the end of today and get you guys a different date and time. So I'm sorry.
So just to be clear, next Monday, we're back together with me doing session 2. So there are a couple of super questions in the chat now, and they're huge, big questions. So I'm going to give a short answer now. You know, you got to tease them to keep them coming back. But we're going to be talking about this stuff over the next few weeks. Jim asks, how does the state provide access to typically developing children without having universal pre-K for 3 to 5 year olds? So Jim, here's the thing. We are at a point now that I could not have imagined when I first started doing this job, because when we all started taking Section 619 money, which, just to be clear, was a little before I was doing this job. I mean, I'm old, but not ancient. There was no public pre-K at all. It didn't happen. And now I'm sure one of the DOE folks who's participating in this is immediately going to tell me the actual number. But there are a boatload of SAUs that have public pre-K programs. Now, that doesn't mean that those pre-K programs are universal, even in that district. But the number of opportunities that we have now to have children with disabilities age 3 to 5 in quote unquote regular education settings is off the charts compared to where we've been. But that doesn't mean that it's not a constant issue. It is not universal, and in some cases, we're working with partners who aren't entirely certain yet what their obligations are under the law. So we're going to work on this as we work through the class. But yes, the United States Department had what had to have been a 10-year battle with the state of New York about this, because about 15 years ago, the state of New York basically said, okay, we understand how this Part B 619 thing works. If anyone opens up a public pre-K program, we'll make sure they get Fape. And the US Department said, no, that's not how it works. If you take the money, you have to give everyone the Fape. And New York said, no, you don't understand. We don't give regular kids. Don't you love that? Regular kids. Have you ever met a regular kid? I'm pretty sure I haven't. Anyway, it does not mean just because you give some regular kids public education, you only have to give some students with disabilities one. And that went back and forth for so long. I mean, you gotta love New Yorkers. They do not give up the ship easily. So we'll get back to it, but yes, you have to find opportunities where special education is delivered alongside typically developing children, even though we are not at universal pre-K.
And we're continuing to develop our options for least restrictive environment and training for those who provide. So we are continuing in that plight. Someone wrote a question about how things are different because of COVID, which is a great question. And here's the real answer is nothing is different due to COVID. IDEA is still everything that our timelines, our obligation to meet with IEP teams. There are no waivers. There's nothing different about our practice in terms of IDEA and the laws that we have to follow. The difference may be right now in how we are providing services, because we are providing services sometimes in hybrid or remote settings. But there is no change to any of the federal requirements or the state requirements around special education because of COVID. So I just want to make that clear, people know that.
Okay, so here's when attorney and client get to respectfully disagree. Attorney says, everything's changed. My God, I'm sitting at my dining room table and my legal assistant has fur. And frankly, I'm in the luckiest 0.0001%. Yeah. So we are going to talk about COVID life as part of this class. On Friday afternoon, I received the 86-page gulp decision from a New York State court in a case that purported to be a national class action brought on behalf of every child with a disability in the United States against every state and every local education agency, alleging a denial of FAPE because of the pandemic. The judge, I have to say, was genuinely unamused by this case. And most of it was for like lawyery reasons. I'll give you a hint. You can't just bring all 50 states into court in New York because you picked New York. There are a bunch of legally, jurisdictionally problems with it. But you know what the case stands for in my mind, other than the fact that I managed to get dismissed without doing anything?
Nice job.
The judge said, in a pandemic, there is, in fact, a lot of flexibility that the US Department of Education has given, and everything about IDEA that remains the same starts and ends with the most important part. IDEA is individualized. There is no solution that fits everyone. Oh, look, here it is. I knew that I would get a stat if we hung on long enough.
Thank you, Leanne.
Leanne, expert. So there you go. We've gone from almost zero to, I mean, I think 80% isn't close to almost all. It's not all. Yeah, I know. Don't send me out to count any crowds either.
Thank you, Leanne. That's awesome. Thank you for that. Yes, there have been a lot of cases around COVID, and one thing is clear is that they are taking cases individually. You can't do everyone got denied Fape during COVID. You can't make that claim. You can't make it for a state, and you can't make it for the country, and you can't make it for the world. By the way, yes, everyone did get limited education during COVID-19, but
they got different education.
Different, you're right, different. Thank you. Yes, but the law still remains in place. So things have changed, absolutely.
Don't you love it when your client's the one saying, but the law remains in place?
It does remain in place.
I train you so well.
I always think of the law, as you know. All right, well, let's see, there may be one more question. Nope. Okay, so Colleen has clarified that the link is the same link that we're using today. So if you keep hold of that, you should be good for Friday. It looks like we're having well under the anticipated levels of participation. So we'll keep this Zoom link available for you guys next week. And I will put out in the next day or two when we'll do that Q&A thing. It'll probably likely, we'll give you some more information about that. I thought those were already determined, so we will get you that information. Other than that,
Erin,
yeah.
How do people find the recording of this if they have colleagues who weren't able to join us today because, oh, I don't know, they were actually educating children?
Well,
Erin, you want me to jump in and give you that information?
I would. Mm-hmm.
So the Maine DOE has a YouTube channel that everyone can subscribe to. I did send the link to the YouTube channel in the email, but if you just go to YouTube and search Maine DOE or MDOE, you will find it and the recording will be posted there.
We have captured all the names, Colleen, of who is on this call, so don't worry about putting your name in a chat box. We know who's here. We have your name captured. Roberta, something special they need to do, or we're just going to use their names and give them contact hours.
After today, we'll probably put a code in for the last slide, and then you can submit your codes that you have other than today. We'll figure that out, but moving forward after today, we'll make sure that Sarah has a code in the last slide so that you can send an email, and we'll give you all that information and just tell her how many sessions you attended, and then you'll get the contact hours for each session. That's how we typically do it.
Okay.
Secret code. This is almost getting cool.
I know.
Wait,
and you know what? This is
the first prize too.
A what?
A prize if you know the secret code.
No, but you
get contact hours. That's the prize.
Oh, what an exciting prize!
It's a good prize. It'll help.
No, not exciting.
So
I'll
one person
with Fape Cat, he might have a prize.
One person let us know that their name is not as it appears on their screen. So if you have that situation, please let us know and we'll make sure we take care of that.
Oh, that's sad. CDS sites were told not to join the live because it was too over-enrolled.
Yeah, well, we were prioritizing CDS employees because this is for you guys. So there was a lot of other interests outside of CDS. So CDS folks, you have this live link. Other people, if we had gone over capacity, would have had to see it on the live stream. So if you're working in CDS, which many of you are, then please use this link in the future.
Okay, I don't know who Sloan Overlock is, but she's really popular because they're like a bunch of people that are turning up as her.
She must. Interesting, very interesting. Well, she does have a cool name, whoever she is.
Oh,
she's here.
She's an office operations manager.
Oh, there you go.
I like
She's
it.
Denise's office operations manager. I have no clue why that is happening where my staff are under her name.
And it's okay.
Cool.
We will get that figured out. No worries there. All right. Okay, everybody, we're going to end the call right now. Thank you. And we will see you next Monday. Have a great week. Last full week before Thanksgiving. I can't believe it. Have a good one.